G'day and welcome back to A Legal Studies Teacher Reads the News. I read this article yesterday about this horrific situation, and it is a really clear and helpful case study for you to use in legal studies, which covers a whole range of syllabus points and really, really helpful if you're going to think through and use it well. So I thought I'd just spend some time looking at what Megan Davis has written here in an opinion in the Sydney Morning Herald on the 8th of November 2021. I'll start reading, I'll look at a couple of the issues, and then I'll talk about how it relates to the syllabus. Still, they take the children away while our report gathers dust. 2 years ago, almost to the day, I received an email advising me that the Family is Culture report into Aboriginal children and young people in out-of-home care in New South Wales had been publicly released. As chairperson of the review, I had mixed feelings about this. On the one hand, I was hopeful. Our report was comprehensive. It had been commissioned by the New South Wales Department of Communities and Justice to arrest skyrocketing rates of child removals and Aboriginal kids in out-of-home care. Over 3 years, we have forensically reviewed the case files of 1,144 Aboriginal children who'd been removed from their homes. We had established an Aboriginal reference group, engaged with Aboriginal communities, received submissions, and analysed data. Okay, so Family is Culture. This is the report. Now, this is an example. If we're looking through now, this is the report, and we're going to spend a little bit of time looking through this. It's 500 pages, so when I say a little bit of time, I'm only talking about, we'll look at a few pages and talk about it. When it comes to the syllabus, I've got it opened here at human rights, and there's a reason for that. If we're thinking about promoting and enforcing human rights, very much the right of a child to be treated in the right way by their government is up there when it comes to human rights. So in Australia, we're talking about the incorporation of human rights into domestic law. We're talking about statute law. We're talking about non-government organisations, the media. It really comes down to also you can have a Charter of Rights, and you can have this as a contemporary issue, looking at the promotion and enforcement of human rights of Indigenous children. And we're going to see it's not just Indigenous children as well. And that's one of the things that I'm talking about when I say this is a really integrated study. Because if you think about it, this is a review that was asked to occur by the government, as Megan Davis said. Okay, independent review of Aboriginal children in out-of-home care. That's what that stands for. And here we've got Gareth Ward, the Honourable, maybe not so more, MP, Minister for Families and Communities, Minister for Disability Services, asking for them to do a look at and kind of discuss how this law can be improved. All right, so we'll jump down a little bit, and it's talking about there's a whole bunch of good stuff in here, but I want to only look at a few things to show you what this is in relation to law reform. So, terms of reference. So this is basically what Megan Davis has permission to do. So she's been appointed by the New South Wales Minister of Family and Community Services to chair an independent review into Aboriginal Torres Strait Islander children and young people in out-of-home care. They will conduct the following: oversee an independent review aimed at improved implementation of the Aboriginal and Torres Strait Islander Child and Young People Placement Principle, Children and Young Persons Care and Protection Act of 1998, especially Section 13, identify the reasons for the high and increasing rates of ATSI children and young people in out-of-home care, and develop strategies designed to reduce the number of these children, and improve pathways to family reunification. The review will include, although not be limited to, a contemporaneous review of case files, consultation process, including but not limited to the ATSI children and young people in out-of-home care, their families, etc., a reference group of relevant ATSI stakeholders and experts who will meet no more than 4 times during the review period. The person will then provide an interim report and make recommendations. So this is very clearly a law reform at its very heart. So we can go back to here law reform. Conditions that give rise to law reform, including changing social values. So this is in the preliminary syllabus. Concepts of justice. Agencies of reform, including law reform commissions. Okay, so this is right here at its very heart, law reform in action. So it's partly this, examining conditions and describing the role of agencies, but also obviously law reform in action as well. So you can use this and talk about this as a contemporary law reform on top of the native title there, if you so wish. So it's in the syllabus as well, and obviously we're thinking through law in practice. It can obviously be talked about there as well. But when we talk about, so that would be there, groups or individuals suffering disadvantage, and then you're looking at the criteria to evaluate the effectiveness of the law. And you have to say here it's pretty ineffective, but we'll get to that. And then obviously we've got human rights and issues of compliance and non-compliance in relation to human rights. We're going to see the role of law reform in protecting human rights and the effectiveness of legal and non-legal measures in protecting human rights. So as you can see, this hits multiple syllabus dot points and themes and challenges. And that's something you want to think about in legal studies. You want to find an issue that you go, boom, I can use it here, here, and here. Okay, and we're going to see that. So if we go down, this is the Megan Davis's forward, which she talks about a whole bunch of things. And I'm just going to look at a couple of quotes that she's got. Okay, so for example, the state has adopted many rituals of listening to Aboriginal peoples, from government advisory committees to glossy brochures and policies espousing self-determination and reconciliation action plans, but it does not often hear what Aboriginal people are saying. Okay, so that's a direct criticism of the government, and it's this kind of, here is this problem of you know, the if we're talking about it, kind of compliance and non-compliance, but I guess the development of human rights is a reflection of changing values and ethical standards that people want to be listened to and heard. And here we've got a couple of things she says. If we go down, when we have power over our destiny, our children will flourish. They will walk in two worlds, and their culture will be a gift to their country. Okay, so this is a great quote about Indigenous communities and the importance of children as the destiny of their people. We've got some more here where she discusses, so this is all the submissions, all the figures that she's talking about. And then she discusses here abbreviations. All of this you'll find in any government report. Okay, so this is an example of where you can show students what occurs. This is why it's 500 pages long. Okay, executive summary. This is kind of her in a nutshell. So if you don't have a whole bunch of time, you can jump to the executive summary and read through that. And some of the quotes here. Okay, so the current system of prenatal reporting, investigations, and newborn removals is flawed and is having a significant impact on the number of Aboriginal children entering out-of-home care. Okay, so this is most certainly the effectiveness of legal measures in protecting human rights. It's also, if we look at other parts of the syllabus, it's a problem with, where are we? In Australia, so the incorporation of human rights into domestic law, as it's the current system of prenatal reporting. And the media is certainly having a role as well, because we're going to read what Megan Davis says. Here, the review found a substantial level of non-compliance with the requirement to conduct safety and risk assessments. So, yet again, directly, issues of compliance and non-compliance in relation to human rights. It concludes that it's time for the New South Wales Government to formally acknowledge to Aboriginal communities, as well as the broader Australian community, that, as an ostensible parent, it can and does cause harm to children for whom it has parental responsibility. Okay, so that's really coming down to responsibilities of the government. The Australian community, very, very interesting quote there. Okay, so this is made a whole bunch of recommendations here. This drift, and this is some. I'll get into this in 2 seconds. But let's read it out first. This drift of children from out-of-home care into the juvenile justice system is of paramount concern to the Aboriginal community, as Aboriginal children are more likely to be affected by this phenomenon due to their gross overrepresentation in the out-of-home care system. Okay, so she makes this link here between out-of-home care and the gross overrepresentation of Indigenous children within it and them entering the juvenile justice system. And I want to bring that up, and we'll look at this argument, this Julie Power article as well, which is talking about, so 3 graphs talking about Australia is not closing the gap between Indigenous statistics of Indigenous people and the rest of Australians who are non-Indigenous. And 3 things: high rates of Indigenous suicide, overrepresentation of Aboriginal children in out-of-home care, and adults in prison. They've all worsened. And what she says here, which I thought was a very good point, is here. This is basic human rights. If children can't be kept in a safe and nurturing home, they find themselves in the criminal justice system. All these things are interrelated. It is a pretty strong indictment on the nation that we still can't get these fundamental human rights in balance, he said. So that's James Christian, the Chief Executive of the New South Wales Aboriginal Land Council. Okay, so very much this link is being made between out-of-home care and the criminal justice system. So here's the graph. By 2025, increase of the proportion of Aboriginal and Torres Strait Islander children enrolled in year before full-time schooling. All right, so you've got, this was the target. They've done well here, as you can see. So nationally, in 2020, 93.1% of Aboriginal and Torres Strait Islander children were enrolled in a preschool program. Okay, so they were seeking to do that, and they've done that. However, the rest of the stats, nowhere near as good. Okay, so estimated life expectancy, look at that. Okay, so shocking, the difference between those. It really is. It is. You know, we're talking nearly a decade here. Okay, between males and pretty much a decade for females. So these graphs here are talking about the problems. And Indigenous children out of home care. Okay, so this is 4 months ago, talking about how the fact that it's still increasing. And look at the difference. Okay, so overrepresentation is shocking. That was the target. Look at where they're going. They're going up and not down. Okay, there's Megan Davis again talking about it. And yeah, the Indigenous incarceration rate, as you can see, going up. So why is that? Why am I linking these, apart from the fact that they are linked? Well, because that means for the legal studies syllabus, you can actually talk about it here in crime. So issues of compliance and non-compliance in regard to criminal law, the extent to which the law reflects moral and ethical standards, the role of law reform in the criminal justice system, and the extent to which the law balances the rights of victims, offenders, and society. I mean, thinking through these, how are these not connected? So you can talk about, you can introduce this issue into your crime extended response. Okay, and if we're thinking through things like factors affecting criminal behavior, crime prevention, situational. Sorry, not situational, social. Investigate a range of situational and social crime prevention techniques. So one of those techniques surely is to improve how many children are going into out-of-home care and get that number down so that that strong link between out-of-home care and the juvenile justice system can be broken. Once again, and you've got alternative methods of sentencing, including circle sentencing. So that's there. We're talking about that in relation to Indigenous groups. Young offenders. So age of criminal responsibility, that's a big one that's separate, and that has huge rates of Indigenous people who are overrepresented. We've got alternatives to court. So there's a whole range of things that you could actually bring in to this when it comes to this issue. Let's see what Megan Davis has said. We'll go back to human rights for this. We then produced the 434-page report, which included 126 recommendations that, if implemented, would significantly reduce the number of Aboriginal children entering care. On the other hand, I was apprehensive. Child protection is an area characterised by government inertia. In other words, government's not doing anything. The grandmothers against removal we worked with kept saying the recommendations would collect dust, as is the case with most national and state reports on Indigenous policy. Was this report going to be yet another dust-gathering exercise, or would the government read about the failures of its bureaucracy and its policies, hear Aboriginal calls for reform, and fix a system that has been failing us and our jarjums, our kids, for decades? The sector's response to our report was overwhelmingly positive. So here, the effectiveness of legal and non-legal, in particular, measures in protecting human rights. Shortly after its release, more than 20 civil society organisations, including ABSEC, the Aboriginal Legal Service, SNAKE, the National Voice for Aboriginal and Torres Strait Islander Children, and the Public Interest Advocacy Centre, wrote an open letter to then Premier Gladys Berejiklian, calling on her to make serious and genuine change to reduce the gross overrepresentation of Aboriginal children in out-of-home care by implementing all of the report's recommendations. This letter had little impact. The department's first formal response to the review, just 5 pages, remember this is a 434-page report, acknowledged the confronting stories of Aboriginal children, families and communities attempting to navigate the child protection system. It announced a handful, remember, 126 recommendations made, a handful of reforms, some of which were not even recommended in the report. So they've literally done 5 or 6 reforms, some of which, so more than one, weren't even one of the 126. This measly response was the textbook department ritualism my report spoke to. Despite the outward appearance of compliance, endless glossy brochures and lip service to change, it shields an entrenched culture of non-compliance. Issues of compliance and non-compliance in human rights. So Megan Davis, remember, she's a professor of law. She was the one that was asked by the government to do this review. And she is here straight up saying they have this ritualism where they basically pretend they pay a lip service to change, but they don't comply with their own stated goals and aims. Inexplicably, the department deferred all recommendations for legislative reform until 2024, when it proposed to review the Children and Young Persons Care and Protection Act of 1998. Since then, the department's released 2 further progress reports. While some recommendations inch forward, key foundational reforms, such as those aimed at embedding much-needed independent oversight of the system, have been largely ignored. Other recommendations remain stuck in the scoping and planning phases, with no detail provided about timeframes for their commencement, let alone completion. One issue that particularly shocked us during the review was the number of Aboriginal newborns removed from parents shortly after their birth, often from the hospital and sometimes without warning. Remember, this is like, if we're thinking about human rights, my gosh, that is appalling. And it wasn't just the numbers that were concerning. We saw worrying examples of deficient and unethical casework in this area and recommended the department revise its policy on prenatal reporting and newborn removals as a matter of urgency. Bureaucrats cannot be conducting themselves in this matter on behalf of the state. We suggested the department implement a system to ensure that most at-need expectant parents receive early casework support. Okay, so surely this is thinking about the rights of citizens. Yeah, if we're talking about the definition of human rights, having your child taken away from you while in the hospital and without warning, my gosh, is that a breach of human rights? It's a breach of the fundamental concept of it. And if we're thinking about it, it should be, most certainly, under statute law, not possible. Not possible at all. Despite the clear and pressing need for reform in this area, the department's last progress report stated the updates on these recommendations were unavailable and would be provided in the next reporting period. Can you imagine if I, as a teacher, sent a report out and simply said, your child has been in my class, and look, their grades and marks are unavailable, but I'll make sure you get them next time I report to you. That's not good enough. Meanwhile, Aboriginal newborns continue to be removed at unacceptable rates, and questions remain about the department's casework in practice. Only a few months ago, a district court ordered, so this is common law, roles of common law, a district court ordered the department to pay costs in a case where its pre-planned removal of a newborn baby was precipitously premature and lacked the required factual consideration. Non-compliance. In this case, the judge found that although the mother understood parenthood and passed fitness assessments, the department determined a plan in which the mother would be prohibited from breastfeeding and breast milk would be provided to the newborn through a bottle without the mother present. We found department conduct towards mothers and newborns cruel and inhuman. Okay, so that is the official report, which was asked to be completed by the government. 2 years after the Family's Culture Report was released, I again call upon the department to implement the full suite of recommendations, to engage in genuine partnership with the Aboriginal stakeholders and communities when developing projects and policies, and to embrace the shift in practice that is needed to preserve and work with Aboriginal families. Aboriginal children deserve better. Like all children, they deserve to flourish with family and their culture. We have presented a comprehensive roadmap that will make that happen. Now is the time for the department to commit to the journey ahead. Megan Davis is a professor of law and UNSW's Pro Vice Chancellor Indigenous. Okay, so as I said, it's a shocking situation. It is an example where the government clearly is in breach of its responsibility to its citizens by not complying with its own legislation about what it's supposed to be doing. The practices clearly don't have enough oversight and regulation. And when it comes to the effectiveness of legal and non-legal measures, in particular, the role of law reform, in that they have asked for a report. The reports, remember, was 3 years in the making, and 126 recommendations were called upon, with non-legal organisations calling for all measures to be accepted. 2 years later, we've had a couple of incomplete progress reports and a handful of reforms, some of which weren't even part of the 126 recommendations. As stated in the other article, that is a strong indictment about Australian treatment of Indigenous people when it comes to out-of-home care. And as we've seen here, the strong the relationship between out-of-home care and juvenile justice, leading to the overrepresentation of Indigenous adults in prison at rates that, frankly, are just not good enough. All right, so a really helpful study to look at when it comes to human rights, when it comes to crime. If you're in the preliminary, looking at the concept of law and practice and groups that are disadvantaged and evaluating effectiveness, as well as you could talk about disputes, because we've got a dispute there, looking at the couple that took the government to court, and the district court ordered them to pay costs. In this case, the pre-planned removal of a newborn baby, and obviously law reform as well, contemporary law reform issues, and how it works with different mechanisms and agencies and the like. Okay, so hopefully a bit of a longer video here, but hopefully that's a good example, and people can take what they want away from this, and hopefully the government actually starts to take its responsibility seriously and starts to actually implement some of these reforms, if not all of these reforms that Professor Megan Davis has called for. Thanks for listening.